Court does call the case of the people of the state of Michigan versus Philip Carrick.
And is that on behalf of the people, Your Honor?
Good evening, Your Honor. Sam Bernstein with and on behalf of Mr. Carrick. Appears by Zoom.
And this is the people's motion to modify bond. So you may go ahead.
Your Honor, at this time,
Okay, pause for context. This is a bond modification hearing. Basically, the defense wants to change the terms of bond, while the prosecution argues he's too dangerous to be out. Watch closely. This isn't just about money, it's about safety, accountability, and whether the system trusts the defendant to follow the rules.
we agree with requesting our original request of $500,000 cash surety, as well as if he is to post or be released for a home confinement tether. Your Honor, I'm not sure if the court had enough time. I know we submitted this late last night to the court, this motion, so I'll kind of go through it a little bit. Your Honor, in the instant case here, to start out, the entirety of the events of this case from March to July occurred while the defendant was either on bond for a strangulation or after he had pled to a DV second in Judge Simpson's court.
This is brutal testimony. The prosecutor isn't holding back, listing every violent act to paint a picture of escalating abuse. Think about it. These details aren't just shock value, they establish a pattern. And in court, a pattern of violence is one of the strongest arguments for keeping someone locked up.
In this case, the victim has laid out a series of assaults starting in March through July that include the defendant assaulting her in a numerous variety of ways, including kicking her, throwing her down, punching her, biting her, and choking her. And in some of these events, some of these specific events that stick out to the people, Your Honor, include an event where the defendant is alleged to have strangled the victim and taken her keys and her phone and had been sleeping by the door to hear when the victim tried to leave the apartment. She did attempt to leave the apartment. He then chased her down out in the parking lot, bear hugged her, and then told her that if she were to make a scene, he would, I'm sorry, Your Honor, give the correct quote that she was stating, that if you make a scene or you scream out, I'm going to effing kill you, and then told her to get back into the apartment. Your Honor, after that, I also have concerns that at one point she was strangled to the point of unconsciousness, which in our eyes is mere seconds away from death, and she did have to go to the hospital and get treatment. Your Honor, along with this report, there are numerous images of...
Here's the kicker. He allegedly committed these new assaults while already out on bond. That's like breaking the rules while you're already being watched. Question for you all. Should someone who repeatedly violates bond ever be granted another chance at release? Drop your thoughts below.
Injuries that she sustained, including bruising to her arms, bite marks, bruising on her neck, as well as a extremely large, I would say, bump on her forehead from these assaults from this defendant. He has threatened her numerous times throughout this case. In one of the points where he was strangling her, he told her she wasn't going to see her children tomorrow. She's had a black eye from this defendant. I also have concerns in this case that it occurred while he was on bond. He has a previous history of domestic violence, and in one of those cases back from 2023, he had picked up a case of domestic violence with a victim. While on bond for that case, he saw her at a bar and assaulted her again for that case. And in that specific case, the assault that he did left bruises on this victim. He had put his hand around her neck and a pillow over her face during the course of the assault, and she was so afraid and traumatized from this assault that she had fled the apartment the following day and then fled the state. And then, continuing on in his criminal history, he just pled in a case for a DV second, which includes pretty similar behavior of strangulation and domestic violence. He's continuing this pattern of aggression and abuse towards women, and it seems to be escalating in this case, which has led to these charges of unlawful imprisonment, GBH strangulation, as well as domestic violence in numerous instances. I have great concerns. I also have concerns that in this police report, she also alleges other violations of bond of him being at bars drinking, which was against his conditions of bond, and that also matches what the victim impact statement was in Judge Simpson's court, that she saw him at this specific bar that the other victim mentions he was at that time. I mean, I have great concerns that he cannot follow court orders. He is a danger to the women around him and a danger to the community. I mean, he continues to not follow court orders, assault women, And I have extreme concerns for the community's safety as well as just women in the community in general, given his behavior. He cannot follow court orders and continues his pattern of aggression and abuse against numerous women. He now has 3 different victims of domestic violence against him. It is a pattern of behavior that's extremely concerning to the people. And I believe a request of $500,000 cash surety as well as home confinement is helping to protect the women of our community from his abuse and aggressiveness towards him. I'm sorry.
Yes. Was it yesterday this defendant was sentenced?
He was sentenced, Your Honor, on Tuesday.
On Tuesday.
To domestic violence second offense. This report came in on, I believe it was made on Monday. We did not receive it till that morning / afternoon on Tuesday.
So, and that's what I just have one question. So Judge Kunke, when she sentenced him to the, I think it was 1 year probation or something like that, was not aware of.
She was surprised, Your Honor, of what was in the process of going on. And at that point, we had tried to get this complaint sworn to and have officers present to initiate this case. However, we wanted the other case to proceed as it was up for sentencing that day. So Judge Kunke was apprised of what was in the process of happening at sentencing.
Got it.
Did you catch that? Once the tether, basically an ankle monitor, was removed, the violence allegedly escalated. This is the exact nightmare prosecutors warn about when arguing to keep monitoring in place. The lesson here: sometimes removing restrictions can open the door to more danger.
Okay.
And I also wanted to note for the court as well that the context of these events at the beginning starts after the defendant's tether had been removed in the previous case after exam. That's when the beginning of these events start up until July of this year before he was sentenced.
What do you mean his tether was?
He was on a tether in the previous case, Your Honor, at the start of that DV case. And after exam, there was a motion for the tether to be removed and the tether was removed. I believe it's a hot zone tether in that case.
And then the behavior begins.
Correct.
Your allegation. All right. All right. Ms. Bernstein, respond.
One thing I want to point out, Your Honor, is that in the emergency motion, it states that the magistrate gave Mr. Carrick a $50,000 cash or surety bond. That's not actually what the bond is that the magistrate gave. He gave a $500,000 bond with a 10% privilege. And there is actually a significant difference between the two in terms of the amount of money that is required for him to get out. So at this point in time, he posted a bond which required paying a bail bondsman $12,500, which he can't get back. And so the bond that's posted for him right now is $125,000. So it's not an insignificant amount by any means, and it's much, much more than what would just be a $50,000 cash bond.
So what you're saying is the bond is set by he's posted?
It's posted, Your Honor. I think he's being held pending this emergency motion.
Yes. Okay.
What I think, but I mean, my point there is that it's actually much higher than is stated in the motion. I know it sounds similar, but mechanically, it actually is much more difficult to post that as 10% of $500,000 rather than a $50,000 cash surety bond. So it's not small. At the arraignment yesterday, Magistrate Odetella did say that he had participated in the swear-to. He had heard everything that has been said now. He had also reviewed the bond recommendation, Your Honor. Submit to the court that the bond in place is actually quite high, and it's not an abuse of discretion to give that type of bond in that amount. It's not a low amount by any means. It's different than $50,000 cash or surety. It is a significant bond, Your Honor, and I don't think Magistrate Odetella abused his discretion in setting that bond.
But he was on bond at the time of the occurrence of this offense, correct?
That's the fact pattern, Your Honor.
Yeah. Okay.
And Your Honor, there is one more thing I want.
Now the judge steps in, and you can hear the frustration. Judges hate when defendants commit crimes while on bond. It undermines the whole system. And the judge here is signaling, this might have been too lenient to begin with.
To add as well, I know it came up in arraignment about the timing of the report, but I did want to say in the report, the victim states to officers that she had come in to report this because of her daughters and her children, and that she cared about the defendant as a person, but was terrified of him and what he's done and did not want her daughters to have to go through that as well. And that's why she came forward. It wasn't with malicious intent.
Anything else, Mr. Murphy?
What I would ask the court to take into consideration if the court is considering raising the bond at this juncture is that he has committed significant reliance on the bond as it was given yesterday. And so we'd ask the court to please take that into account when considering a bond at this point in time.
The concern that I have is that he's on bond for a domestic and this occurs. I'm also concerned that the defendant seemingly gets off a tether and then the behavior begins to escalate, which is, I think, in a certain respect, for this court problematic, and I think should have been taken.
And there it is, the ruling. The judge removes the 10% option, meaning no more shortcuts. If the defendant wants out, it's the full $500,000 cash only. That's a massive wall to climb, and essentially keeps him in custody unless he's got serious resources. Big move.
To the extent the magistrate knew, could have been taken into further account. I also am not sure, because frankly, I don't believe that, given the fact that the defendant was on bond, which may entitle him, quite frankly, to no bond, because he was on bond at the time of this offense. The magistrate chose to give him a bond, but I believe the granting of the 10% privilege is certainly problematic with all of those other circumstances before, meaning that if he's on bond, certainly I think it's an abuse of discretion to give them the 10% privilege on the bond. So the court will grant the people's motion. Yes, I will grant the people's motion. The defendant's bond in this case will be modified not in terms of its cash component of the $500,000. I will leave that in place, but it will be cash as surety, no 10%. So I'm removing the 10%, but all of the other conditions that the magistrate set in place, the court does find appropriate, and those would remain in place.
So are you going to continue to be a GPS tether and not home confinement?
If he posts, I would change that to a home confinement. All right, got it.
Thank you.
Could he be released for work, Your Honor?
Pardon?
Could he travel to work? No,
If he posts, I'm going to do it. If he posts, then there would be a home confinement tether. I will certainly take a look at what the work schedule is. I doubt that there would be agreement between the parties as to what that work is. But if he has a regular work schedule or however that is set up, the court will